Hi, my name is Robert Shelley with Shelley Law, and my firm assists physicians with employment contract issues. Today I'm going to talk about what are some reasons behind breach of contract for a physician employment agreement. So what are the things that an employer could terminate a physician for, and then alternatively, what are some things the physician could terminate the contract for? So first, let's go through how a contract can be terminated, and then we'll kind of go through the specifics of each of those. So first, in any contract, it'll usually be for a fixed term. So let's just say it was a 2-year contract. If both parties decide not to renew the contract, the contract would just terminate at the end of the 2-year term. So that's one way. Contract could terminate due to mutual agreement. So both parties decide it's not working out. We're not going to wait till the end of the term. We're just going to terminate the contract now. They can also terminate the contract without cause. So any physician contract is going to have language that just says either party can terminate the contract for any reason with a certain amount of notice to the other party. In most cases, it's usually either 60 or 90 days. And then finally, the contract can be terminated for cause due to a breach of contract. And in this case, the employer will list a whole bunch of things that they can terminate the contract over if the physician breaches the contract in some way. Many times there is no language at all about the specifics of how a physician can terminate the contract if the employer is in breach. So first, let's just go through kind of what are some normal reasons that the employer could terminate the contract. So one, if the physician loses their license. So let's say the medical board in their state decides they're going to revoke the license of the physician. Clearly, the contract will be terminated. They can no longer practice medicine. They have their DEA registration taken away, which almost in every setting would not allow them to do their job effectively. They are excluded from billing and are placed on the Office of Inspector General exclusionary list. CMS has a list that basically, if a provider does certain things in a negative way, they can be put on this list, which then would exclude them from being able to bill under Medicare and Medicaid, and that would, for the most part, make it impossible for the physician to practice. Most contracts state if the physician is given a felony, so usually convicted of a felony, that would be grounds to terminate the contract. The physician is uninsurable, so maybe they have a number of malpractice claims or settlements, and then there is no insurance company willing to offer them malpractice insurance. In that scenario, an employer just isn't going to keep the physician around. Pretty standard things. There's usually some kind of morals clause that just says the physician will present good character, get along with others, and then usually there's something at the end that just says for other good cause, or for other good reasons, which is obviously very broad. They can kind of shoehorn that in. So if the physician is in breach and there is some way to fix it, there's usually language in the contract that's called a cure period. So they'll normally state if one party is in breach of contract, the other party gives them notice. They said, hey, you're breaching the contract. And then there's a period of time they have to fix the breach, usually somewhere between 15 to 30 days. Now, obviously, if you're a physician and have your license revoked, you're put on the OIG list, your DEA registration's taken away. These are things that cannot be remedied in 15 to 30 days, and the employer will just immediately terminate. Now, there are things that can be fixed. One is I talked about before with the morals clause. So they say you're not getting along with others, you're not presenting good character. Here are the things you can do to fix these. The physician can then attempt to fix them within that period of time. And then the employer would then have no ability to terminate them for cause. Now, as I said before, the physician can always be terminated without cause at any point with a certain amount of notice. So maybe the employer doesn't have the grounds to terminate the physician for cause after they've fixed a breach, but then they could still just give them notice and get them out after that period of time. Now, there is also usually language in the termination clause that states if an employer gives, let's just say it's a 60-day without cause notice, the employer provides the physician with 60 days, but they say, we don't want you here anymore. Even though we have to provide you with this notice, don't come to work tomorrow. Well, the employer would still have to pay the physician for those 60 days because they were terminated without cause, but they don't have to provide the physician, the entire period of time to work there as well. Now, on the physician side, normally the things that they can assert that the employer is in breach of contract. One, if they're not being paid in time, maybe they have some kind of bonus and it's not being calculated correctly or paid out on the time that the contract states. Maybe the physician is not being properly supported via staffing. They don't have the proper MAs or an office manager or front office staff to work efficiently. Maybe they're being asked to do some things that they believe is either unethical or illegal in some ways. So in that scenario, I always suggest you need to let the employer know that they are in breach of contract in writing so that you are establishing some kind of record of what's going on. Many times I'll talk to physicians who are, they feel like they've been aggrieved in some way and the employer is just simply not providing them with a safe atmosphere, or they're not following through on things that are written into the contract. And my first question is, have you given them written notice? Most of the time it's no. I've talked to them. I talked to the med director. I talked to my boss. Nothing's happened. Well, you need to establish a record. And in that case, you have to provide them with written notice that they're in breach of contract. Most of the time, it's pretty unlikely that a employment relationship would end with a kind of for cause termination due to a breach. Most of the time, in that case, the parties will just agree to kind of move on, or they'll just give them, as I said before, the without cause notice, and then just tell them to go home anyway, pay it out, and move on. Anyway, hopefully that was helpful. Kind of went through some examples of breach of contract for a physician employment agreement, and then kind of how each party can terminate the contract. Hopefully that was helpful. If you have any questions, you can always call my firm at the number listed below in the description. You can reach us through our website, ChelleyLaw.com, CHELLE law.com, and appreciate you watching the video. Thanks.